one ended up on the school.
That does happen,
Happens
right?
a lot.
They'll run and get even.
Oh God, that guy. What was his name? That guy. No, George was his boss. Anyway, he was director of something, and they cut him loose. And that's what she was going to do.
Is that the conference connection? Since about 9:30, Dave.
Hi, nice to meet you, Dave.
However, I'm not hearing anybody on that side at the moment.
I'd like to make an announcement before we start, just for the people in the audience, is that Don Viss will not be able to attend today. Leslie Viss is attending, Leslie Beggs is attending by teleconference, and I think we're working on that right now. Leslie, can you hear us?
Yeah, can you hear me?
Yes, good morning. Okay, so,
awesome.
and I'm just explaining, Darren had another meeting at 9. He said he might be a little late. Lynn's here. I'm not sure about John, but with Leslie here, we have 4 trustees. So I'd like to call this meeting to order, and we will begin. Please join us for the Pledge of Allegiance. Ready? Salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Jan, are there any public comments or anyone sitting here that would like to make a public comment? Okay. No. The purpose of today's meeting is we are going to have a presentation, sort of a training on discipline, due process, and some other things. We're very, very fortunate to have, I didn't realize we we're going to have all 3 of you, but we welcome you. And I need to, from Atkinson, Andelson, Loya, Rude, and Romo is the name of the law corporation. And I'll let each of the presenters, because I'm not sure how you're going to do it, introduce yourself. But this is intended to be for everyone here. It's not just for the board and for you just to, be playing on your phones. This is intended for everyone. And I do believe there may be a time at the end for not only for the board to ask questions, but for everyone to ask questions. So Meredith, I'm going to assume you're going to start off. So, welcome.
Thank you. Thank you, Trustee DeMartini, Board President, all the members of the board, Chancellor, and members of executive staff. And thank you so much, everyone, for allowing us to come here today. I'm probably going to be dancing and kind of moving around because I don't want to have my back to anybody. So we're going to call this the law firm line dance this morning. What I wanted to do was provide a answer to questions that have come up with respect to due process. And I know that this is something that's very much on the board's mind, and I kind of love constitutional law, so I kind of had a great time working on this. And I tend to write a lot. I'm going to tell you that I don't talk a lot, but you'll know the truth in a few minutes anyway. But in any case, this presentation is meant to be something you could use after the lawyers are gone. I am a board member myself, so everything has a dollar value to me, and I want to make sure that when I'm out of the room, you guys still have the information. So it's really a reference book, and it'll be yours. It's yours, and it's available to you. So all that to say that don't feel that I'm going to painstakingly drag you through every single word. And most of it, I'm not, I'll have it on the screen and talk about it. I'm not going to read every line, but it's there for you to use as a reference, as opposed to having to call the lawyer anytime you have a question, or actually have to have the question unanswered. So with that said, I am going to introduce Guy Bryant, who is one of the law partners I work with. He's also my husband. I met him in law school, and so I'm a creature of habit. I sit in the same seat every day in the boardroom, and I married the guy I sat next to in law school. All that to say, if I'm parked next to any of you people, run. And then this is Larry Shanky, who is also one of my, it says of counsel, but I get to call him on his cell phone, so he's really, like a law partner. He doesn't have separation from me. I call him when I need him. Larry has actually worked for the district before, in a life past. So both of these guys have a lot of experience in doing litigation with respect to due process hearings. I litigate and I do a lot of administrative hearings, but these guys have some depth and stories that they're going to be able to share with you and go over some of the hypothetical questions with you as well. So I brought them because they're actually useful. Lawyers sometimes just bring a whole posse with them. These guys actually have something to contribute, and they'll do so. So I'm going to get started, and because I want to leave as much time as possible for questions. So the format of this presentation is we're going to go through the overview, then we're going to go through some ground level United States Supreme Court cases and statutes, and then we're going to, there's some hypothetical questions that I've worked out. I think actually maybe this is the least, this part of the room is probably where I'm like get to see everybody the best. So let's see if I can work this clicker. You know what they say about technology. So this is just an overview of what we're going to go over today. Oh, wait, we have these copies for you too. So, yes. So here's the overview of what we're going to go through. And like I said, I'm not gonna like be a pain and like read the whole overview to you guys. That would be excruciating. So we're just gonna go past this. I would like to say though, one of the things that's important is that when you talk about due process, a lot of it depends on what the interest is. It's based, due process comes from our Constitution, the United States Constitution. It's also in our state constitution. And so with respect to due process, the fundamental rights really are, for an employee, are related to the case that determines that there's a property interest in continued employment in a public position. So that's going to be one of the initial cases, the seminal cases that we go over. There's also what's called a liberty interest, which is a right not to be defamed, a right to have your good name maintained. And so if you're in an employment situation and there's something that's public, that's made public, that's published, that you consider defamatory, there is a right that's attached to that too, which is called a liberty interest exception to due process. So we're going to go through that as well. So I'm going to be really going through the foundational aspects of due process, and then we're going to go into some hypothetical questions that I wrote so that we could practice. And this is a little bit like a law school class. I told you guys, you give a lawyer a mic and a typewriter. I love constitutional law, so by the time we're done with this, you guys are all going to be an expert. I had Archibald Cox as my professor in law school, so I'm not even going to apologize for how much I love this stuff. So that's 2 pages of overview. You see, that is exactly why I can't read everyone. But really, what is due process? I mean, we hear the word a lot. It's a whole lot on TV. It comes out of the Fifth Amendment of the U.S. Constitution. No one shall be deprived of life, liberty, or property without due process of law. And so you'll see throughout this whole presentation how life and liberty and property are referenced, because you're going to say, what's the property interest involved with this or that? And that's what I want you to do. I want you to look at this, keep these things in your head, and see how the thread goes through the entire presentation. So you're going to say, what property interest is involved in this? What liberty interest is involved in this? Those are the questions we want to ask. And that at the bottom it says, what does that really mean? What does it mean to be deprived of liberty or property? And we're not talking about life, because that would be criminal law. That would be, that's a whole nother strain of case law and statute. It would really be property and liberty, liberty that we're talking about, and not liberty in the sense of your freedom, but liberty in the sense of being free from something. And that's where we get into the liberty interest exception about being free from defamation. And then our due process rights for criminal matters the same as civil matters. So you guys are going to be constitutional law experts, and if someone asks you what's the difference between crim law and civil law, you guys are going to be able to answer that when you get done. There will be a test. All right, so what is the property interest in public employment? And also, these 2 guys are going to get up and do the second half, and there's 41 slides. Don't be alarmed, but we'll get through it. So one of the main cases about the property interest in public employment, which I mentioned at the beginning, where does that come from? Who decided there's a property interest in public employment? Well, Skelly versus State Personnel Board, that's one of our California cases, says that it's a landmark case where the California Supreme Court held that a permanent public employee may only be discharged for cause and has a property interest in the continuation of his or her employment, which is protected by due process. How many of you guys have heard of Skelly? Yeah, there we go. There we go. You guys know this stuff. All right, so what is due process? Right here we have the outline. Notice of the proposed action, right? If you have a property interest and someone is going to challenge that property interest with some sort of allegation or some sort of action, you need to know, you have to have notice of the proposed action. This came out of the Skelly case, these things that are listed at the bottom on what is due process. The reasons for the proposed action, and you need to see a copy of the charges and materials upon which the action is based, and the right to respond either orally or in writing to the authority initially imposing discipline. Now, what's important about Skelly is that we're going to talk about not just permanent employee rights. These are like the because it comes out of the Skelly case, which dealt with a permanent employee. These are the most robust rights. Your due process rights are also related to what type of property interest you have. If you're a student, you have due process rights because you have a contract. You have to pay and you get educated. You know, you have a contract. You have a property interest in that. If you're a volunteer, or if you're a trustee, or if you're a adjunct faculty, you have another set of due process rights that are related to not necessarily a property interest, but a liberty interest. So we're going to go through those. What due processes do, or what processes do in public employment. So this is the Loudermill case. And the Loudermill case is another landmark case. That's our Supreme Court decision where the court balanced the property interest in the job against the government interest in the expeditious removal of unsatisfactory employees and the avoidance of administrative burdens. So oftentimes I hear all these jokes about politicians because I'm a board member, a whole lot of jokes about lawyers, you know, God, I'm a twofer. You also hear people talk about public employment. Oh, they could never get rid of those guys. Well, there's a property interest, and people are working really hard, and that, you know, it's a whole lot easier to throw, I think, rocks and eggs from outside of, you know, not really knowing that you have to deal with limited resources. There's always budgetary constraints. There's a whole lot of issues and rules to deal with. But what the government has said is that there is an interest in the expeditious removal of unsatisfactory employees. So for all those folks who are throwing rocks at us, people who are involved in public service and public government, you know, we have a case that says that there's a balancing interest. So you guys remember that next time you hear that joke. So Cleveland Board of Education versus Loudermill says. So what is your due process with respect to public employment? Oral or written notice of the charges. So the question that we're going to deal with is how much detail is that? Because we're going to get down into the weeds a little bit, but not so far down that we get lost. But we're going to answer that question. An explanation of the employer's evidence. When does this explanation occur? How much detail? And do you have an opportunity to present your side of the story? And what type of opportunity to be heard is required? So these questions we're going to answer as well as part of our hypotheticals that we're going through. I'm just laying the groundwork now so that we sort of all have the same basis to have our discussions. And you guys could flip back to these pages too to formulate your questions. Then what is the due process procedure? Now, in law school, we learned this thing called issue, rule, and application, IRAC they call it. That's what this really is. It's, actually, no, this is actually the due process procedure. I'll take you to the analysis part. But the due process is divided into three parts. There's the investigation phase, the post-investigation before action is taken, and the disciplinary process. Why do we have an investigation first? Well, people can they could say anything they want. I mean, that's part of the issue. People can make a claim and it doesn't have to be valid. People can say things out of anger. They could say things out of suspicion. They could say things because they say things. And so before we get engaged, you know, one of the way that we have the process is set up, before you really start spending money doing a whole lot of looking into something or investigating, you first have to find out whether there's any credible evidence, whether there's any reason to believe that there's any validity at all to what's said. So that's that's why we have the investigation. You get a complaint, it could be oral or written. You make sure that you find out whether or not there's anything to it, and then if you find there's something to it, then you actually undertake a more formal process. Post investigation, but before action is taken, you go to the person that is has been accused, and you make a formal, you go through the due process, and you start that process, because then you find out, okay, there's actually something we need to take seriously. Let's talk about it. And then there's the disciplinary process, which also has the rights that we'll talk about in terms of representation and the level of evidence and the level of review. So what process is due? The Loudermill Court held that the property interests are not created by the Constitution, but are created by the statutes that define public employment. So we really get due process from the Constitution, but what the court was saying in Loudermill is that determining actually what your property interest is something that you have to review statute for. And we know that there's different rules out there. There's the Title IX rules with respect to sexual harassment that have their whole list of things you're supposed to do. We also know that there's discrimination claims or harassment claims and all that sort of stuff. And then we know that those all trigger their own type of requirement that an institution undertake. Title VII of the Constitution has its own set of rules. But what Loudermill says is that the property interests are created by the statutes that define public employment, and that means that the property interest for a permanent employee is going to be different than the property interest of employees where the court has not, or the state legislature has not created or sort of encompassed or encased that particular property interest in a protective statute. Public employees do not have presumptive due process rights. There must be statutes, civil service laws and systems, contract rights, established rules and understanding that effectively create a de facto tenure system for the employee to enjoy these rights. So what that really means is if you're a permanent employee, you've got the highest level of protection, and it's embedded in the statutory framework. And also, the question is whether those statutes, contracts, rules, or understandings create a legitimate expectation of continued employment. We also know that the manner in which discipline is carried out, things that affect your employment, are subject to collective bargaining. So that's part of the statutory process. You do have, and then also I noticed we have some officers here. There's the Police Officers' Bill of Rights too that goes in with that as well. So there's a lot of different elements with respect to how the state legislature makes sure we carry out due process, because there are a lot of different interests that we have to balance, and in order to make sure that people are being treated fairly and that they get all the rights that have been recognized and supported by law, so that we can use them in the process. So here's the analysis, here's the IRAC. What is the interest or standing at issue? So that's the issue part. What is the interest or standing at issue? And that's why we've gone through those first couple of slides with respect to the property interest. And the statutory framework, so you're going to be thinking, what's the statute? Does there tenure rights that are continued expected employment? And then also, is it a student? Is it a trustee? Is the person a volunteer? What's the interest or standing at issue? What is the statutory framework applicable to the issue? That's issue, rule, that's the IRAC. Rule is the second one. Statutory framework applicable to the issue, and that's where you throw in the collective bargaining, the case law, the statutes, that goes into the rule. And what is the process outlined by case law, statute, or contract? That's the application. So that's what we're going to do, the IRAC. So we're going to see this a couple of times after each, and also after each hypothetical, and we'll go through this analysis. What type of hearing? So we have the right to be heard, that's part of due process, but that also is conditioned upon, or it's impacted by, the statutory framework. So in the type of hearing, we also want to think about the standing, because there are court cases that we'll see as we go through here that say that educational institutions' first priority is education. If everybody lawyered up for every administrative hearing, it would be taking money out of the classroom. I, as a board member, I don't like spending money on investigations. I could say that, even though I know that they're necessary. every time we could save money, I want to, because you're always trying to figure out what you can do for your students. And so that's why we have there are different levels of required hearing, and it's not going to be the same in civil as it is in criminal, and it's going to be based upon the standing and the statutory framework. So, right to be heard. That may include some or all of the following, depending on the applicable statutes, contracts, or regulations. The right to see the evidence before the hearing, an impartial decision maker. That one's going to be there every time. That's not going to change, that impartial decision maker. That's the foundation of our common law in the United States. The right to attend the hearings, that's going to be there in everyone. The opportunity to have legal counsel, you have that opportunity to have legal counsel, whether the district is going to pay for somebody else's lawyer. I mean, I've heard those questions, but that's more than we could do. A reasonable time to prepare, that's actually a standard too, because you can't have a due process hearing when you give people insufficient notice or insufficient time to prepare. The opportunity to present your own favorable witness testimony and evidence, that's essential as well. And the right to cross-examine the witnesses. So the right to confront the accuser, employee misconduct hearings versus criminal hearing. So with respect to confronting the witness pre-discipline hearing. So remember I'm going to go back to that earlier slide.
Meredith, I have a request from you. Occasionally, would you please mention what page you're on?
Oh, okay.
Because Leslie doesn't have any
I'm
video.
sorry. Okay.
But she has it. She has the presentation on her
Okay.
iPad. But occasionally mention what page you're on.
Okay, so we're going back to page 6 because we're looking at the 3-part of the due process. So remember, it's divided into 3 parts. So investigation phase, we have to figure out whether there's anything to what you've heard at all, because people say things. They're sometimes not. They could be a waste of time to follow up on. If you look at it, but you have to look at it and see whether it's valid. If it's not valid, then you have to spend your time on that. Post-investigation, but before action is taken, that's the Skelly process and the disciplinary process. So we're going back from 6 to page 10. There's no requirement that an employee be afforded an opportunity to confront opposing witnesses and cross-examine them under oath at the pre-discipline hearing. So if you're actually at a discipline hearing where there's actually action that's getting ready to be taken, that's when the right to confront kicks in. Not at the earlier time until you have to figure out whether there's anything to it or not, and whether or not you're going to take action. And if you actually have a threat to your property interest, that's when this right kicks in. However, the 6th Amendment provides that a person accused of a crime has the right to confront a witness against him in their criminal action, and that includes the right to be present at trial, as well as the right to cross-examine the prosecution's witness. Now, state laws defining categories of community college employees. That's page 11. This is an important page because this shows the statutory framework that addresses the different categories of employees that we have in community colleges. So it goes from classified, probationary, permanent, academic certified, full-time faculty, part-time faculty, supervisory, managerial, non-classified service, contract administrators, and confidential employees. So we get to see that there's a whole host of statutes we're going to look at. So remember IRAC, and this is page 11. So you could go back to page 11. You could look at these, and if you want to look up the statutes, you could also see them because the sites are there. Do temporary faculty or adjunct faculty have due process rights? So that's an important question when we do the IRAC, because we looked at the first case, the first case that we looked at, the Skelly case, said that permanent employees have a right to an interest in their continued employment that's considered a property interest. So if you're a temporary faculty member, you may be terminated by the board at its discretion, whereas regular or probationary faculty may be dismissed only for grounds. However, there's a liberty interest in due process. Remember, we talked about that at the beginning. The liberty interest is coming out of the Luby case, which was a California Court of Appeals case that found that temporary public employees may be dismissed without a hearing or good cause, and that they don't have a property right in the continuation of their employment. However, an exception to this rule arises where the deprival of a liberty guaranteed to all persons in the Due Process Clause of the 14th Amendment is at issue. That's applied where the probationary employee's job termination or dismissal is based upon charges of misconduct, which stigmatize his reputation or seriously impair his opportunity to earn a living. And this came out of a case with the police force in San Francisco, where there were three officers that were called in and told that they were fired, and there was some stuff that was said that that was defamatory. And the officer said, "Well, okay, I'm temporary, and you can fire me, but you cannot say things about me that are going to affect my right to get a job somewhere else." And so, what came out of this was the liberty interest. The government can't be unrestrained in the way that it addresses someone's right to earn a living and their right to be free from defamation. So that's what you want to remember in the liberty interest. It may not be that you can't be dismissed. I mean, you could still be dismissed if you're temporary, but you still have to be treated with your rights intact. That's what the liberty interest is. So where is a deprival of liberty interest, the employee's remedy mandated by the Due Process Clause is an opportunity to refute the charges and to clear your name. So we're going to go through the liberty interest exception. All employees have a protected liberty interest that protects their reputation and provides the opportunity to earn a living without the burden of an unjustified and stigmatizing charge of misconduct. And here are the elements of liberty interest. Stigmatizing charge implicating the employee's reputation. Interpret it narrowly. You have a right to deny the charge, and there's also been a public disclosure of the charge. And so I had just mentioned this sort of in summary, but the liberty interest addresses the stigma, not the employment. So it doesn't change the statutory framework for temporary employees, but it preserves your rights as an individual, not to be defamed. So what process is due under the liberty interest? Well, you get a name clearing hearing. And I was talking to someone before that said that they used to call those a white hearing. Has anybody heard that phrase? It was just a catchword. They called it a white hearing. It's probably from another case, not Luby, but that's what they called it. So you get a notice of a meeting before a governmental body for the opportunity to be heard. Liberty interest procedures don't need to be formal and don't need to consist of a traditional hearing. And that's, again, where the government interest with respect to conservation of resources versus the individual interest comes into play. You'll see that when you look at administrative hearings, the level of evidence and the formality, because the more formal these hearings are, the more resources you have to pour into them. Like sometimes you hire another hearing officer, people lawyer up for those, you get a court reporter. I mean, it could get very expensive. So a full evidentiary hearing is not required. And you have a chance to review the charges and supporting evidence and respond in writing. And remember, we said that's going to be that's going to be the thread that goes through all due process. You got to have sufficient notice and a right to prepare and speak on your behalf. And it may be held in conjunction with a property interest hearing if the employee is so entitled. So again, we'll go back to the statutory framework when you're analyzing a liberty interest. So I've come to my first hypothetical. And I'm going to apologize. You know, I get to sit here and write these things, so these are going to be a little crazy. We've got Pablo Picasso here. There's going to be a few more that may gain a chuckle, but I left Kim Kardashian out of this hypothetical scenario. I put her in some. So anyway, this hypothetical, I want you guys to take a look at that, and then we're going to go to the analysis, and I'm going to give you over to Larry and Guy, so that they could do the hypotheticals.
Good morning. I'm going to let you guys have a chance to read it, and Larry and I are going to walk through this with you in a moment. Meredith mentioned, excuse me, that we had Archibald Cox for our constitutional law professor, and many of you may know that he was the Solicitor General for the U.S. government and also was part of the Nixon investigations. One of the things that, I've tried a lot of cases, Larry's tried a lot of cases, and one of the things that I asked Mr. Cox about, how do you make your case to the fact finder? How do you tell the Supreme Court all these complex issues, and how do you help them to come to the correct decision? And he basically said, Mr. Bryan, the law at the end of the day should be understood by an 8-year-old. And we were puzzled. I said, "What do you mean, an 8-year-old?" And he explained, he said, "What is due process? It's not fair. What is a contract? You promised. What is equal protection? Why me? What is civil procedure? This is how we do things. What's real property? It's mine." So I took that and I've taken that every time I've had to make an argument to a fact finding body, whether it's a court, a jury, and others. And I've polled the jury afterwards, and the jury would respond in that level of understanding. At the end of the day, Mr. Bryant, I just didn't think it was fair. At the end of the day, Mr. Bryant, it looked like they were picking on him. Why him? At the end of the day, so what I want you all to kind of think about when you go through our slides and our hypotheticals, ask yourself, was this fair? Did we give this person proper notice? Did we give this person an opportunity to respond? Did we give this person every opportunity to correct their behavior? Did we follow the police POBAR requirements? All those kinds of things. It always comes back down to if you are ultimately challenged with regards to the decisions you make, those are going to be the questions the judge will ask, the jury will ask, the administrative hearing will ask. Was it fair? Why this person? What promises did the board make? Did they have a board policy or an administrative regulation? That's a promise. What collective bargaining agreement was in place? That's a promise, right? So you have to think about it in those terms, and you normally will come out with the correct analysis as to what's appropriate for the particular circumstance. So I hope that's helpful. It's been really helpful in my career. Whatever I'm formulating, when my daughter was 8 years old, I say, "Joy, do you understand this?" And she said, "Yes, Daddy." I'm like, "Great, I know I'm in good place." Okay. Um, or you want to say a few things? Why don't we go through this then? Pablo Picasso teaches 2 Cubism painting classes as an adjunct professor at Catalonia Community College District. And Catalonia is having some interesting times right now. And he is regarded widely in the geographic region as the artist who developed the artistic style of Cubism. The Cubism classes are 2 hours in length, and Mr. Picasso does not teach elsewhere so that he can devote sufficient time to teaching his class and pursuing his artistic craft. 1 week before school is scheduled to begin, Mr. Picasso is notified by the district that both of his Cubism classes have been canceled because a permanent art department faculty member, Piet Mondrian, claims that he, rather than Mr. Picasso, developed Cubism, and Mr. Mondrian will be teaching Cubism at the college. So we can switch to the next one. What do you guys think? What process is due? What kind of interest or standing at issue? What kind of person are we dealing with? An adjunct faculty.
But he has a liberty interest because the community believes that he is the inventor of Cubism.
Thank you, Trustee DeMartini. Correct. Clearly, this sounds like this could be stigmatizing, right? It sounds like he needs to have his name cleared. It doesn't seem like it would be what? Fair, right? If we didn't have some kind of discussion with him. Everyone in agreement? Does it make sense to you? What statutory framework would be applicable to the issue? What do we think? So would it be part-time adjunct faculty? Slide 11, please. So we would be looking at Ed Code 87475 through 87482. However, since it's temporary, probably only a liberty interest type of hearing would be applicable here. Great. And So we have to do a formal hearing? Yes, excellent. It's not a formal hearing, but we do have to provide notice, an opportunity to respond, and have someone be who listened to it. Excuse me. Slide 16, right? It's a name clearing hearing. We would want somebody who's hearing his issue to be someone who knows everything about the case or someone who might be completely non-biased. What do you think? Impartial. Great. So just check that line on slide 16. It kind of gives you the process that would be appropriate.
Could I ask a quick question about
Sure,
that?
certainly.
If the college had just said that Mr. Mondrian's classes haven't filled and he's full-time, and so we're very sorry, Mr. Picasso, you will not be able to teach your classes, then would that have been the end of it?
That was exactly where I was going to go. I
Oh,
was
I'm
going to make the
sorry.
comment. You read our minds, which is an important point.
AP class.
Right. Somewhere in one of these slides, I lost the number, but one of the slides talks about how much publicity there was related to the liberty interest. That's what's important here. In this particular hypothetical, it appeared that there was some kind of announcement by the college. That is the issue that gets you to the point where there's a liberty hearing. I can give you actually a concrete example of that I spent many months and years dealing with. It's all in public now, so I can talk about it because it ended up in federal court litigation. Basically, there was a contract teacher at a community college, and the president of the college had discovered he made the allegation that, or he discovered there was information that she had falsified some records to gain more materials for her class rather than going through the normal process of filing for a requisition and such. At that point, it came to the general counsel in the chancellor's office, and I sat down with the chancellor and I said, "Well, what do you think?" And he says, "This is not really. I really don't want someone around that's going to pervert the system because we can't keep track of the money we have. It's very important that money be spent on students appropriately, and I don't want one teacher having more than another teacher simply because they know how to game the system." Fine. So the investigation was done, and the decision was made to release her as a contract employee. She had no permanent property rights. She had a right to teach the rest of the year. And at the end of the year, as a first year contract, actually she was second year. As a second year contract employee, she had a right to stay to the end of the year, but she didn't have a right to permanent employment. Um, Unfortunately, or fortunately, depending on the point of view of where you're standing, at the time this happened, the chancellor was very concerned about her because things had been turned up in the investigation, and he felt that the district could no longer rely on her and could not trust her. So he put her on what we all know as administrative leave. Administrative leave is basically a process whereby the employee is removed from their duties, but they remain on salary and they're not participating in their normal duties. It's a way to make sure that the employee maintains their quote property interest of being paid until the end of their term, whatever that might be. But the district at that point, or the college at that point, is not at risk to more mischief from the employee. At that point, however, as often happens in community colleges, the students show up to class and the teacher's no longer there teaching the class. Where's our teacher? And it became a very cause célèbre, and there was a number of meetings and protests and showing up at the board saying, "Where's our teacher?" And so,
Never happens here, right?
right. So the chancellor asked the college president to meet with the students. And the college president did, and the meeting was to say, this is what's going to occur going forward in your class. This is how you're going to provide the class for you so you can get the materials. The students kept asking him, what did she do? What's wrong? What's wrong with her? Why are you doing this? And despite good legal advice from the person sitting in this chair, he made one comment, and the comment was, "Well, I don't believe she's going to finish her probation successfully." in public to a group of students. Now, the question becomes, is that really, are you just saying, well, this teacher needs, we're going to have this teacher come in, or I need to transfer this teacher to another place, or someone's going to replace her for a valid reason? We felt that that didn't affect her liberty interests. She felt that it did. She filed in federal court because it was a constitutional violation, and the litigation went on from there. Clearly, she did not have a right to remain in employment with the district. But the question becomes, did she have a liberty interest? The board in that case decided that she did not because the college president simply said she's not going to finish her probation successfully, which is a real common statement from most situations where they're releasing a teacher. But it ended up in federal litigation, and it was settled. We never got a ruling from the court, but I think that's the key is you have to be very careful in these situations when you're dealing with adjunct or contract employees, folks who don't have what we call a continuing permanent property interest in their employment, that you do not release any information to the public to disparage them so they, as Guy pointed out, the issue is impinging their liberty interest in finding another job. And if you think about it, if you all think about it, everybody has an interest in someone else, particularly someone you want to move on, to find another job somewhere else because everything gets more resolved that way. So that's a long story, but it's an actual concrete example of what can happen when you're dealing with liberty interests. So,
And I'll turn it over to Meredith.
So the next section we're going to go through is due process for non-probationary public employees. I do notice I'm the only one in heels and the only one standing. I'll talk about those guys on the way home.
we're
So, due process for non-probationary public employees. Once a public employee passes a probationary period and becomes permanent regular employee, the employer must provide due process before taking that interest. So, the reason that we have this when I'm actually going through it is because here are our bedrock rights. Fair and partial hearing, right to be represented at your own expense, right to introduce evidence, right to confront witnesses against you, right to written notice of decision, and right to seek judicial review. So these, again, we're at the most heavily fortified rights that we have with respect to public employment. So what is a fair investigation? A fair and thorough investigation must include the following things. It must include interviews of the accuser, the accused, and particularly those who witnessed the alleged conduct. That means the witnesses for the accused as well as the accuser. You can't just look at one side and say you've done an investigation. You have to do a 360-degree review. Must include gathering and preserving relevant documentary evidence, and some arbitrators are reluctant to uphold discipline if persons who are believed to have witnessed alleged misconduct firsthand are not interviewed. Some investigators say, oh, I'm not going to ask them. I know what they're going to say. No, that's not going to cut it. You can't presume just because someone may be favorable to one of the other parties involved that their evidence, their testimony, can be just taken for granted. You have to, it doesn't matter if you think you know what that person's going to say, you still have to do a thorough investigation. You have to talk to everyone who has relevant evidence, particularly the firsthand witnesses. Due process through the, we have a question here?
No, excuse me. He needs to speak into the microphone because we have a trustee who's listening and only hear through mic. Thank you.
If we have a permanent employee and they move jobs, is that same thing apply? They're still permanent, but they get a different position, or should that be addressed in the contract?
We all can chime in on this one, but normally just moving a different position, you still maintain some permanency. You want to touch in on that?
It will depend a lot on the. Oh, here you go. It will depend a lot on the board policies and the contract provisions, but when you're transferring someone, generally it's for the needs of the district, and they're simply being transferred. Now, once again, going back to the liberty interest, if someone is transferred and somehow there's some publicity of something that was a negative connotation, then that person may have a liberty interest hearing right, but it wouldn't be a deprivation of property right. So it's a different analysis. But they still have their job. I mean, that's the bottom line. But they may have the right to name clearing.
And we're assuming it's not a demotion. Yeah, it's just a flat transfer. Yeah. Um, okay. I was going to touch on something real quickly on that last slide. When you do investigations, the concern that most boards and administrators have is how far into the rabbit hole do you go? Because sometimes there's so many new witnesses that may come up, new documents that may come up, and often, whether it's Title V investigations or other types of investigations, you have a timeline. You have 90 days to complete your investigation. You may have to report something to the state chancellor's office, et cetera. So that's where the relevancy issue really comes in. Whoever is your investigator, whoever is the party that's supervising this investigation, whether it's a Title IX person or student services chancellor, vice chancellor, or some HR review, there has to be some clear guidelines as to what is it that is at the heart of the complaints or the issues that are going on, so that you can have a focused investigation, because not everything is going to be relevant. So that's the challenge that has to be worked out. And I like to call it thought partnerships. You have to have a thought partnership with those who are engaged in that investigation, so that they're all kind of seeing things from the same lens. When you have investigations, you have Garrity is a Supreme Court case. Basically, if it's a dismissal matter, you can require the employee to provide information with regards to the misconduct without the fear of the Fifth Amendment. You know, a lot of times folks say, I'm pleading the Fifth. I'm not saying anything because this may result in some criminal behavior. They don't have that right with regards to their right to hang on to their property interest, the job. And so basically the Garrity warning, you are ordered to truthfully and completely answer questions posed to you during the internal investigation. Nothing you say, nor the fruits thereof, may be used against you in any later criminal proceedings. That you're giving them that advice, but they can then be held accountable for their failure to cooperate with you. California has some additional cases that have kind of added onto that. Yeah. So Spielbauer is the most recent California case, and that also came after the Liebarger case. Oh, yes, thank you. Slide 22 for those listening.
Thank you.
Don't mean to forget about you. I'm so sorry. Slide 22. Basically, the California Supreme Court stated that it was a well-established public employee may be compelled by threat of their job discipline for failing to answer questions associated with their potential criminal misconduct. They can't rely on the Fifth Amendment. And the next slide, slide 23, I believe, is Liebarger. So Liebarger is a common admonition that's very similar to the Garrity admonition, where you tell the employee, look, what you say may not be held against you in criminal, but you need to tell us what happened. And it's very important, particularly if you're dealing with situations dealing with some kind of a serious assault issue, that you really need to be able to get clear information, particularly if it's a safety concern with regards to your campus and those kinds of things, that you really need to be able to get that information. You want to add anything, Donna? Sounds good. Okay. The next thing is, if you're dealing with represented employees, classified, faculty, et cetera, is known as a Weingarten right. In other words, the issue is you're going to have a discussion with this employee that may impact negatively their placement in their employment, their property interest right, and potentially their liberty interest right. And so Weingarten is an NLRB federal decision that basically says that whenever you're going to have that kind of discussion with that employee that is an investigatory interview, or it could be you're getting ready to sit down to give them a letter of reprimand or something else that may negatively impact their employment status. They have a right to a representative. Now, Weingarten doesn't say it has to be a union representative. It could be their grandmother. It could be their uncle. But they have to have a right to a representative at that time of that meeting. And then there's a question as to what do you do? Do you meet with, as the person who's meeting with them, as the manager that's meeting with that particular employee, do you also have someone who's in there with you so you're not outnumbered 2 to 1? So that there's a clear record as to what was said and how it was said? Because that can also be an issue. So that's what's called a wine garden, right? And you'll hear that very often. Unions often will say, what about the wine garden? You failed to have me present as the union representative, for example, when you handed this letter of reprimand or when you confronted this particular person with all these charges. They were not properly protected. Was it fair? That gets back to that issue.
I have a question on Weingarten rights. Is that for all, like you're talking about union employees, would that cover adjuncts? Okay.
Depends if they're represented by a union. Just to kind of close the loop on that particular issue, Weingarten's a federal decision, but the Public Employee Relations Board, which is the California state board that covers public employment, has adopted the Weingarten rule as a rule for public employment in California. Right. So the next slide is 25. This is the new legislation that I have still. Anyway, what it's based on is, I guess, some concern over the years when placing someone on administrative leave. There is no real statutory, regulatory, or even a lot of case law on this particular issue. And so the legislature stepped in and has created this process by which applicable only to community colleges. Doesn't apply to K-12. So we do community colleges and K-12. So there's some stuff that parallels and some that doesn't. In this particular case, they've adopted this statute, which is very, like I said, it's very complicated. We'll find out how it works. But generally, in administrative leaves, I think, I want to go ahead and start in the next slide. Why don't we go to the next slide, Meredith? This is the hypothetical, and I'll give everybody a chance to read it, and we'll kind of talk about this as we go along. So it'll take about 2 or 3 minutes for everybody to catch up. Slide 26, it's the second hypothetical. Starts with Ernest Hemingway, one of my favorite authors. Interestingly enough, this sort of foretold my story. I didn't write this hypothetical, but I can tell you this is true. These things happen. I've lived this. Basically, the summary is Mr. Hemingway is a teacher. He ordered some materials, some actual animals. Well, I mean, we're on a campus here. The West Campus, as you see, is an agricultural campus. It's very possible that we want to order this many. Of course, I don't know how many to do with 30 raging bulls. You don't really need that many. I know that for a fact. And the chancellor finds out this is happening and says, well, wait a minute, what's going on? Very much like the chancellor in my situation said, well, we got to sort this out. We have to just hold this teacher back from doing these things because they cause this problem. This particular problem with 30 raging bulls would be a real safety issue, it would appear. So what now is, what processes do Mr. Hemingway? Going back to the last slide, 25. Pair of glasses, I can't see it anyway. Basically what the legislature has said now is that community colleges, before putting Mr. Hemingway on administrative leave, there's this process you have to go through. In the old days, which actually is now, because I think this is effective probably January 1st. This will be the coming year. Basically, now, if it happened now, the chancellor would simply have the college president talk to Mr. Hemingway and say, hey, look, there's this problem. We're going to look into it. And in the meantime, please go home. Also, keep in contact with us. Oh, wait, by the way, give us your keys. We're changing your password. And here's a short letter saying to you, dear Mr. Hemingway, you're on administrative leave pending investigation into this matter. We will be in contact with you. Please contact us once a week, or twice a week, whatever. Keep in contact with the Vice Chancellor of Human Resources. We'll get back to you. That's what's done now, generally. Now, under this process, there's a much more complicated process, and I think you can read it to yourself. You can read for yourself what this is going to be. This also does something that's not been in effect before. In paragraph 3, it says within 90 days of placing that person on involuntary paid administrative leave, the employer must complete the investigation. Currently, there is no time limit on completing investigations. And in fact, I have been involved in investigations that have gone for a year, 2 years, year or 2 years. I think the longest I had was 2 years. Although I generally advise clients to, let's wrap this up as quickly as you can, because no one is served. The employee's not served, the college is not served, the students aren't served for letting things go on and on and on. In this particular case now, the community college would have to finish the investigation and then decide what they're going to do, either initiate charges or reinstate the employee. So this is the brave new world coming January 1st, 2018.
Thank you. I just wanted to add a little bit of background. A lot of this was driven from a local faculty union at Contra Costa Community College District, and the original language was much more restrictive as far as from the standpoint of the college, putting even harsher timelines and more upfront information that needed to be provided from the outset. And this is a much nicer balance. At the end of the day, you want to be fair. And I think the purpose of this legislation, at least the intent was, we don't want any gotchas, right? We don't want to play a gotcha on a poor administrator or some other employee that here you're being placed on administrative leave. No one knows why really, and you're just hanging out there swinging in the wind. This kind of tries to bring some clarity as to give us some kind of a statement within 2 days before you're going to place this person out, and or if they have to immediately be taken out, 5 business days thereafter, they need to receive some kind of understanding as to why they're being placed on this leave. So I think this strikes a much better balance. 90 days is not out of the ordinary for most investigations. Title V wants you to take care of most investigations within 90 days. The challenge will be perhaps negotiating with your different unions to say, you know what, nothing and we had the benefit of talking to some folks from the state chancellor's office yesterday, that there's nothing that would stop the parties from mutually agreeing to go beyond the 90 days, because sometimes depending on when this occurs, the information comes, the school may be out of session, witnesses may not be around, and it just may be reasons why the 90-day timeline just cannot be satisfied. So, getting back to our hypothetical, we're dealing with a permanent member of the English department, maybe even a chair, I don't know. What is the due process? Is it just a liberty interest? No, right? It's a permanent, right? So we would have a property interest in continued employment, correct? See a lot of heads nodding. Board members, heads nodding? Yes, okay. Out there in the webosphere, head nodding, trustee? We're on
Yes.
Oh, wonderful. So we're on page 26. So we're going to have a much more robust kind of a due process. We're going to have the investigation, obviously, and then we're going to have some kind of a more evidentiary type of a due process that would be due. And we're on page 27. Slide 27, what does the process do? I think we've all agreed on a much more robust due process. The standing is obviously initially property interest. It could also involve a liberty interest. Thought partner exercise question, can you do both at the same hearing? Liberty interest and property interest at the same hearing? Yes, great job. Okay. And then we've already talked about the statutory framework and what we've talked about as far as if this person is represented, they would have a right to a representative, like a Weingarten right or a Garrity right at that stage. Here you go, Meredith. Sorry.
Can I ask a question?
Sure.
Okay, on slide 26, where it talks about the being provided with the general nature of the accusations made against him or her, how precise is that? I mean, how general is general? I'm just curious.
Great question. There's a lot of discussion going on amongst the attorneys in our craft as to how general you need to be. And also, given the nature of the allegations. So that's something that we're all going to be talking about as far as at this point in time. The thought is a very general because you don't know how public this kind of a thing might turn into. And we're also concerned about if you limit yourself to what the allegations could be, then you may be precluded later from adding to what you've discovered. So those are all the things that are being discussed.
So what you really want to do for due process is make sure you say enough to inform the person of what the charges are. And in our hypothetical, we know that we've got the bulls and the invoice, right? So we've got the safety issue, we've got the invoice that didn't go through procedure, and so that we know enough about this to include that. If there's something else that you find out, say you do some sort of review and you find out that Ernest may have shown up and made the decision to do the order when he was drinking. Okay, we're using Ernest Hemingway, so say he was
Right.
drinking when he did it. And you have rules about being intoxicated on campus. Well, you want to say, you want to be able to add that later, and that's what Guy meant when he said you want to be general, so you could say there was a safety issue and a failure to follow procedure and campus rules, right? That sounds really general, but if you don't know that he was 3 sheets to the wind when he made the order, you can't say it at that time, but you could say it later. And so what you're trying to do is you're trying to make sure that you give Mr. Hemingway enough information to know why he's been placed on administrative leave, but you have a responsibility to enforce the rules of your campus because you have to make sure that students can show up with an expectation of safety and that their professor is going to be actually ready to receive them to provide the education that they enrolled for. And so that's why so general means you try your best to get as much information to that employee as possible without making it, you also don't want to defame Mr. Hemingway because you don't want to impinge upon, you don't want to stigmatize him. So that's why the wording gets a little bit difficult. How do you inform someone, but you want to make sure you're not saying things that are really, that he would be injured by?
And
So at that point, it's public? It's not just somebody at the upper levels telling Mr. Hemingway privately?
well, the concern is that Mr. Hemingway may make it more public once you give it to them. The other issue is normally
Okay.
in these circumstances, you would like to, from the employer's perspective, you would like to be able to, at that same time that you're delivering the message, to be able to remove that employee from the circumstances, as Mr. Shanky was telling you earlier, how it currently works, so that that person can give you their keys and they can no longer perhaps erase evidence, exfoliation of evidence, or create any further mischief. This does create that concern that you have to give it 2 days beforehand And so that's a bit of a challenge for us to continue to think about and work out how would we actually do this. And that's why it may be necessary, particularly if you're dealing with folks who are represented, that you come up with some kind of a negotiated process for how we would handle this. And then for those who are not represented, a board policy potentially to address how this would be done in a very orderly way, because you don't want things occurring at one campus different from a different campus, because then you start getting that question of why me? It's not fair, right? So I think we had another question from the audience.
Thank you. I had a question with Weingarten. So you said if you're reprimanding an employee, that they have to have a representation there. What if you're in a standard standing one-on-one meeting and you're giving points of improvement in that meeting that could potentially lead to discipline if they're not improved?
So there's a difference between a letter of warning, a letter of concern, and those kinds of things that are not necessarily going into the personnel file. We all know there's no such thing as two personnel files, right? No two official personnel files. There should only be one. But we all know that as a manager, you often have your site file. You have information that you're receiving with regards to people you supervise that you're just keeping an eye on. You may have heard some issue from, a student complain about a faculty member or some other kind of issue, but it hasn't been really truly validated as something that needs to go into their personnel file. But under 87031 of the Ed Code for community college districts, that when you are ready to put it into their personnel file, right, then it wouldn't be fair if they didn't have an opportunity to receive it, an opportunity to attach their own response to it. And the Weingarten, right, would also give them an additional fairness of having someone there that they can talk to about receiving that. Okay, so that's kind of how that process would work.
Here you go. Perb has talked about this on a number of occasions, as you can imagine. It comes up quite frequently. At a certain point, Perb has recognized that a supervisor has the duty and the authority to supervise the employees and to direct the work. And Perb says if a supervisor is simply meeting with an employee, say, look, I need you to clean these classrooms. They're not getting done. What do I need to do to help you to make you do that? That doesn't implicate the Weingarten rights. But if you meet with the employee and say, look, I've been tracking you for 2 months. I've seen these things are wrong, and here's in writing. And I'm going to give you a reprimand. At that point, then the Weingarten will come in. The Weingarten rule basically is, remember, it's just one person to help the employee meeting with the supervisor to talk about things that may lead to discipline. But simply supervising an employee and directing their work is not leading to discipline. We hope, because we hope that 99% of the time, that's what supervisors are doing.
Exactly. Just to piggyback on what Larry was saying, and we're still on slide 26, is that the goal is to coach up employees, and we want you to manage as a manager, as a supervisor. And, the typical example is, you've noticed that this employee has been late to a couple of meetings, and you may have talked to them orally about it, and then you talk to them again a second time, and then you may shoot them an email saying, hey, do you understand that we're supposed to be on, our meetings are supposed to be timely, and everybody else is there. And yeah, we don't like emails. We don't, but it's still a writing. So anyway, then you give the person a letter of warning. You say, look, I remember I talked to you verbally on this date and on that date, and then I also even sent you an email on blank date or a letter. Here's a letter of warning. You really need to be present at our meetings. It's causing this kind of impact on our department or what have you, but you still haven't yet made that decision that you're going to send it to his personnel file. If they are late again, you have that one more time where you say, okay, I'm going to attach that prior letter of wording to this letter of reprimand, or it could be a part of your evaluation, which goes into their personnel file. And at that time, that's when you would want to have the wine garden rights. And I would also want to stress, whenever you're in this world, talk to HR. Have that thought partnership relationship with HR so that they are aware, because they may have reasons for why this person may be late. They may know about some Family Medical Leave Act reason. They may have a medical issue or taking care of an elderly parent or something. And you want to make sure that you're not penalizing someone unfairly.
So I just went back to slide 5. Is that 5 or 6? 5. Okay, Loudermill, right? So what we're talking about is, when do you do the wine garden rights? It goes also back to Loudermill, where the Supreme Court had said that the governmental interest in expeditious removal of unsatisfactory employees and the avoidance of administrative burdens and the risk of erroneous termination have to be balanced. Really, you're constantly doing a balancing test. That's the great part about constitutional law: liberty, and being able to be in a society that actually, where people can work together, is the balance. You don't want to make your over litigate things, and so you want to have people free to be able to talk to each other regarding, you got to be on time. But if it gets to the point where someone actually is going to have something go in their personnel file, which could be used against them in terms of their property interest, that's when it gets to that level of seriousness. So it's, again, our United States Supreme Court with respect to the balancing. And that is slide 5.
Thank you.
Anyone else have any more questions? Okay. Okay, we'll take a break, and I'm going to go back to the slide that we were at. Where were we? We're going to go to due process for students next, which will be, and so we could take a break now if everyone would like to take a break for maybe 5 minutes.
7 minutes. 4
Se-
minutes after the hour.
7 minutes. That way we could be sure where the longhand on the clock should be.
I mean, I'm just saying. Yeah, it's 40 minutes long.